Uninsured motorist coverage is typical coverage that policyholders buy to protect themselves if they're injured as the result of a negligence of an uninsured or underinsured motorist. So let's explain both of those. Uninsured motorist is obvious. That's someone who has no insurance at all. But most companies are also required to offer insurance called underinsurance, which means if the person that damages you doesn't have enough insurance, your insurance policy might kick in to provide additional coverage. Whatever amount of insurance that other person has is considered an offset. So you don't get to stack. In other words, you don't get to add your insurance together with what they have. But uninsured or underinsurance is a very unique aspect of insurance because it's not third-party coverage, it's a first-party claim, and you're making a claim against your own insurance company. So your insurance company has duties and obligations to you that they wouldn't have to a third party. And in cases involving underinsured motorist coverage, it's a very different area of law, and it's very difficult to bring a case against your insurance company later. So let's discuss the different types of underinsured or uninsured motorist claims that might exist. Well, once you believe that you've been injured as a result of an uninsured or underinsured motorist, policyholder has to notify their insurance company and has to let them know what the status of the claim is against that individual or against their company. If they truly have no insurance, the company is going to require proof. If they have insurance but not enough, then your company is, in some respects, going to become an adversary of the policyholder. They're going to look at the policyholder and try to determine whether or not they were fully compensated, whether or not they have more serious injuries or damages. And one common mistake that lawyers make is they think that if they make a demand upon the uninsured motorist carrier, the insurance company, and the insurance company doesn't pay that demand, that they can go beyond the policy limits. That's not accurate. It doesn't apply in underinsured or uninsured motorist coverage. The most the policyholder can generally recover under the insurance policy is the stated amount of the policy. There's no excess insurance. So you need to make claims for the amount of policy as quickly as possible and provide information to your insurance company. But don't think, as some lawyers do, that you can blow the cap or the lid off of the policy. In underinsured motorists and uninsured motorists, you can't. What you can do is make a claim later that the insurance company acted unreasonably. How do you make a claim that an insurance company acted unreasonably under the uninsured or underinsured motorist coverage? How do you make that claim? How do you advance that claim? Well, you have to show that they had an opportunity to settle early. You have to show that they breached the contract by not settling early. You usually have to actually go all the way through an uninsured or underinsured motorist arbitration proceeding. And then and only then can you bring a claim against your own insurance company for breach of the implied covenant of good faith and fair dealing. Or in other words, for insurance bad faith. You're now bringing a claim against your insurance company saying that they acted in bad faith because they didn't pay your uninsured or underinsured motorist claim quickly enough. And what are the damages from that? Well, that's the difficult part, because you have to establish to a jury that you suffered some harm as a result of the delay. And in order to do that, you usually have to have a fairly extraordinary case. You need to be able to look at the facts and circumstances and say that I lost my home because they didn't pay it quickly enough. I was out of work, they weren't paying me for the time off, so I had tremendous financial difficulties. It's a pretty high bar to be able to reach. It doesn't mean that insurance companies don't act in bad faith, but in order to get damages from the bad faith, it's usually a more difficult presentation than in other areas of insurance law. And then, and only then, if you establish damages, you establish bad faith, can you seek punitive damages. It's much more difficult in the uninsured motorist world than it is in other areas of insurance bad faith.